Hi, Emily here with Apex Law School Prep and Support. Today we're going to run through question 4 of the California February 2023 bar exam. Let's get started with the calls of the question. What ethical violations, if any, has Andy committed? Discuss. So ethical violations. Finally, we've come to our PRSA and answer according to California ABA authorities. That's standard. The way they ask for PRSAs is any splits that you know between California and ABA. You'll want to give those in your rule, apply them, see if things are going to come out differently. Okay, let's jump into the fact pattern. Lawn care company, lawn care, manufactured and sold a liquid weed killer for lawn care. Paula brought a personal injury suit against lawn care when her children developed breathing problems after lawn care's weed killer was applied on her lawn. Lawn care entered into a valid retainer agreement with Andy, an attorney, to defend lawn care in the action. Okay. So first of all, I should say whenever I go through a PRSA, the way that I always structure my answer is act by act. So I'll flag each action that the attorney has done that I think is plausibly problematic, and I'll put an underlined header that summarizes what that act is. Then under that, I'll have a separate IRAC for each duty that is plausibly triggered by that action. So here I see entered into a valid retainer agreement. It's valid. They're making that a non-issue. I'm not going to bother taking time to IRAC my rules for retainers and fee agreements and stuff. I guess if I have extra time at the end of the essay and I really don't know what else to do, I could throw that in, but it's just like in contracts. When they tell you it's a validly formed contract, you don't need to IRAC whether it's a validly formed contract, right? So what can you do from this paragraph? Well, they've told us it's a personal injury suit and Andy, the attorney, is going to defend lawn care in it. Anytime that they give you the subject matter of a lawsuit in PR, I always am going to IRAC competence. So here I would put, Andy, takes on defense of personal injury suit, or, Andy personal injury suit, something quick as my first underlined act. And then under it, I'm going to put underlined competence. That's the first duty I'm going to IRAC. So competence, if you know, right, there's this split in the ABA. You have to have the knowledge and thoroughness and skill and preparation that's reasonably necessary for the representation. In California, you can't intentionally or recklessly or grossly negligently or repeatedly act without being competent. I'll put that if I know the split, or I'll just put whatever rule I know. And then here, they haven't told us what Andy's experience is, right? Sometimes they'll tell you, oh, it's a personal injury attorney, and they've done that their whole career, and now they're taking on a capital murder case. We don't know yet what Andy does. He's just an attorney. So we don't know if he's competent. So I would give those rules. I would also add on, that an attorney can either be competent at the start of the case, or as long as before they're required to perform in the case, they become competent, either by doing research or consulting with another attorney or partnering with another attorney. That's all fine. That will all satisfy the duty of competence. And so here, since they gave me no facts, let's just say as long as Andy meets that standard, he's fine, no violation. I'll get in and out of that real fast. Probably faster than I just talked about it. That's, I think, all I would do with that first paragraph. So let's keep going. Andy is a member and financial supporter of Citizens Concerned About Chemicals, C2AC. Member and financial supporter, a consumer group that is currently lobbying for environmental regulations that would remove chemicals such as lawn care's weed killer from the market as unsafe. Okay, so Andy has agreed to defend lawn care in a personal injury action in paragraph 1, but now we find out he is a member and financial supporter of a group that lobbies against lawn care, maybe not them specifically, but chemicals such as lawn care's weed killer, right, as unsafe. That screams to me conflicts, right? So my next, and I'll get through this paragraph before really figuring out what I'm going to do, but I'm anticipating that my next underlined act is going to be, Andy in C2AC, right? Something short like that. And then my first IRAC duty under that is going to be loyalty, because there is a personal conflict here, right? So the duty of loyalty says that you as a lawyer have to put your client's interests above everybody else's, right? You can't have an actual or a potential conflict. You have to prioritize your client. You can have a problem with that if there's a conflict between one client of yours and another, right? This client you're supposed to put first. If there's some conflict with some other client, that's a problem. If there's a conflict with a third party, like a third party payer, or if there's a conflict with a lawyer's personal beliefs. And that's what jumps out to me here is personal beliefs problem, right? So Andy seems to personally believe that lawn care's weed killer is unsafe because he wants it removed from the market. He's part of this group. maybe, maybe he's going to argue he doesn't actually personally believe that specifically about lawn care, but it looks kind of like he does. So I'm going to say there's a conflict between Andy's personal beliefs and this representation of lawn care. When that happens, when there's that personal conflict, the lawyer is still allowed to take on the representation if he fully discloses his personal beliefs to the client and they give written informed consent. So the informed consent thing, if you know there's a split in ABA, the client can give you oral consent and you can confirm it in writing, like an email or a text. In California, the client actually has to write out the consent. Who cares if you know that split, if you do throw it in. But I'll see where this is going, but that's what I'm anticipating talking about here is a personal conflict between Andy's personal beliefs that lawn care's weed killer is unsafe, and then his representation of lawn care, where he's presumably going to have to argue that it is safe in defending this personal injury action. Okay, so that's what I see there. Next sentence. Andy provided pro bono free legal advice to C2AC in the past regarding an unrelated corporate matter, but did not enter into a formal attorney-client relationship with C2AC. Okay, so that looks like a former client conflict to me. So I think I would then, as my next, I had my one IRAC where I had the underlined, he's a member of C2AC with my loyalty. I think I'm going to make a new underlined where I say, Andy, legal advice for C2AC. And then under that, again, loyalty. And this one, the conflict that is screaming out to me is former client, current client conflict. And so that's, between two clients. So the fact that it's pro bono free legal advice is a red herring. It doesn't matter if your client's paying you, they're still your client and you still owe them duties. Regarding an unrelated corporate matter, he didn't enter into a formal attorney-client relationship. So no formal attorney-client relationship. Again, you don't need to execute some formal, retainer agreement. If you're providing legal advice, he's giving pro bono free legal advice, the duties are still going to apply. So I would point that out, right? I would be like, doesn't matter that it's free, doesn't matter that there's no formal relationship. He's going to owe duties to C2AC. It's really mouthful, unfortunate name they've given this, but okay. But then they tell us in the past regarding an unrelated corporate matter. So when you have a former client, current client conflict, that conflict arises if those interests are materially adverse, right? If your current client's interests are materially adverse to your former client. Material adverse usually means there's some overlap between what you did for the old client and what you're doing for the new client. So here they're saying it's an unrelated corporate matter. So what I'm thinking about that is that means that there's not going to be any, it's not going to count as materially adverse because it's about something entirely different. So I'd probably say there, I give my definition of former client conflicts. If it's materially adverse here, not materially adverse because it's an unrelated corporate matter, seems to have nothing to do with it. But then I want to cover my bases and I'm be like, well, but in case, right? However, in the event that it is seen as materially adverse interest, because this whole entity C2AC seems to be, very like antithetical to lawn care. So I could say something like, however, in the event that, and then I would throw in the attorney's still allowed to take on this representation if he meets RDC, right? If he reasonably believes that he can represent this current client adequately. D is for directly adverse. The client's interest can't be directly adverse. And then the C is for that informed consent. So in California, it has to be written by the client, ABA, it can be oral and then confirmed in writing by the attorney. So I don't see anything here in this paragraph about whether he got any kind of consent. So far not met, but let's keep reading. Since Andy is convinced that his association with C2AC will not affect his representation of lawn care, he did not tell lawn care about his relationship with C2AC. So there it is. So did not tell. So no informed consent here. Lawn care is impressed with Andy's reputation as a litigator, and Andy did not want to jeopardize losing lawn care as a client by discussing his private concerns about their chemicals. Okay, so that second sentence is more personal conflict stuff, right? Like he is now prioritizing his own interest in keeping his client over lawn care's best interest of like fully disclosing his personal beliefs so that lawn care can make an informed decision about whether to hire him. So I would sort of add that to the personal beliefs part. But that first sentence, so since he's convinced that his association with C2AC will not affect his representation, he doesn't tell lawn care. So I'm going to put that in that RDC. So that reasonably believes he can effectively represent lawn care. He's convinced that his association will not. So he's convinced, he subjectively believes that he can effectively represent lawn care, right? That this, both his, personal beliefs and his, prior pro bono free legal advice, he's convinced that those won't affect his representation. Is that objectively reasonable? Because he has to reasonably believe that. I don't know. You could argue both ways there. It's, maybe not, but I would argue it. And then, the clients can't be directly adverse. So his representation of C2AC was former matter in unrelated corporate matter, so that's not a problem. And then that written informed consent, that's a problem. There is no informing whatsoever here because Andy did not tell lawn care about his relationship with C2AC, and then they have not consented. So RDC is not satisfied. So what I would come out with as for the personal conflict is he did not fully disclose it and get informed consent. And then as far as the former client conflict, I think their interests are not materially adverse because it's a totally separate matter, as unrelated corporate matter. But then to cover your bases, run through RDC and say that's still not satisfied. Questionable whether he could reasonably believe that he could effectively represent lawn care. Maybe he could, maybe that's not a problem, but definitely no written informed consent here. Okay, so I think that's all I would do with that paragraph. Although I guess when I see, okay, Andy did not want to jeopardize losing lawn care as a client by discussing his private concerns. If I have time, they're saying he didn't want to discuss this. I would throw in an IRAC on duty of communication. So you have to communicate stuff with your clients, including anything that could reasonably affect their informed consent. So here, I'm going to say he's choosing not to discuss his private concerns about the chemicals. Had he chosen to discuss that, that could actually affect lawn care's informed consent. They might decide they actually don't want this seemingly conflicted attorney representing them. So I would throw that in IRAC if I had time. Okay, next paragraph. In response to an anonymous questionnaire sent to all C2AC members, Andy mentioned the publicly available information regarding Paula's complaint filed against lawn care, but did not provide any other details. Okay, that's screaming out to me duty of confidentiality. I think they're trying to trip you up by saying it's publicly available. So that duty of confidentiality is really broad. It's much broader than the evidentiary privilege. So duty of confidentiality protects all information from any source that you learn in the course of representing your client. You're not allowed to disclose any of that information if the client wants you to keep it confidential or if it could embarrass or harm your client. And whether it's publicly available doesn't matter as long as it meets that standard, you can't disclose it, right? Subject to some exceptions, which don't seem to apply here. So I would say here, this is a violation of the duty of confidentiality. Like, yeah, it's publicly available, irrelevant. What matters is that this information could harm the client. And he learned about it, presumably, right? Paul's complaint filed against lawn care. Presumably, he's learning about this through his representation of lawn care, defending against this complaint. So I'd say because of that and because there's no exceptions that apply, duty of confidentiality violated there. Okay, next sentence. 1 week after Andy returned the questionnaire to C2A2, Andy received a call from the Chief Executive Officer, CEO of Lawn Care, the client, an employee of the client as well, who said a representative of C2AC had called to ask about Paula's lawsuit. Okay, Andy told the CEO that he did not know where C2AC would have received that information from. It's a lie, and recommended that Lawn Care not disclose any details about the suit. Okay, so I see two things going on there. So I'm gonna, underline as my next act. Andy says doesn't know, or something fast to that effect of, right? Basically, Andy lying to CEO. And I'm going to put under that duty of integrity of the profession. It's always my fallback if I don't know what else to do. But the idea with that is you have this duty to promote public confidence in the legal system and the profession of lawyers as a whole to make it all look upstanding and make lawyers look honest and trustworthy. And lying to your client, I don't know where they got that information, that clearly violates that duty. So I'm going to say that saying he didn't know where C2AC would have received that information, that violates that duty of integrity of the profession. And then I suppose Andy could argue that it's not a duty of violation of the integrity profession because he doesn't know for certain where C2AC received the information. Since it's publicly available, they could have gotten it, from checking the docket or whatever. But I think to make lawyers look upstanding, right, he should err on the side of caution and really to not violate the duty of integrity. He should be disclosing, he should be forthright to his client and say, hey, I don't know for certain if this is where they got the info, but I did tell it to them. And then, I think you could also, if you have time with that fact, throw in a quick IRAC about loyalty. I think, again, he's letting his personal interest in retaining lawn care as a client take precedence over his duty of loyalty to lawn care by giving them all this information. And then I think you could also throw in, if you have time, duty of communication, because I think lawn care knowing that their attorney did this anonymous survey and disclosed this information that he shouldn't have, I think that could affect their informed consent. And so duty of communication says that Andy should tell them this. And then I would just do one last IRAC for this recommending lawn care not disclose any details fact. The first thing that I'm like tempted to talk about there, which I'm not going to, but what it makes me think of is your duty of fairness to your opponent. Ordinarily, you're not supposed to advise people not to talk to opposing counsel, and except if they're the client's employee or relative, and won't harm them. And here it's the CEO, so it's the relative. But he's not advising him not to disclose this to opposing counsel. He's advising him not to disclose it to C2AC. So just irrelevant. So what would I talk about for that fact? I mean, I guess duty of loyalty, like, yay, Andy's finally being loyal to his client, advising him, not to disclose any details, because he wants to probably preserve, the evidentiary privilege, confidentiality and whatnot. And I think that's fine. I don't really, know what else I would say about that, except like that's okay for him to recommend that lawn care not disclose the details. So I think that's all I would do for this fact pattern. There might be more stuff, but that's all that jumps out at me. So hopefully that was helpful.